Good afternoon, everyone, and welcome to today's session, Reimagining Patents Act 1983 Towards Sustainable Support of Innovation. So as an introduction, I'm Munirah Maarof, the moderator for today. Assalamualaikum. I'm from Norizan and Associates. My background is basically I'm an intellectual property lawyer as well as an IP valuer. And I'll be moderating today's session with our panelists for today, Dr. Chris Hemingway and Mr. Kandiah. So let's kick off the session now with a brief introduction of the event today. So we had about 157 pre-registered for the webinar, and I can see now there are about 84 participants joining, and more people are starting to join the session. So welcome again to today's session, which is hosted by Malaysian Productivity Corporation Malaysia. For about the GRP webinar. This is a series where we provide a platform where we bring experts to share information and best practices regarding good regulatory practices, or GRP. It covers various topics to help policymakers, regulators, businesses, academia, researchers, and interested parties to enhance knowledge on how to improve the quality of regulation without slowing economic growth, innovation, competitiveness, and job creation. So today's topic is an intellectual property topic on Patents Act, Reimagining the Patents Act 1983 Towards Sustainable Support of Innovation. So today's topic is basically about how we live in a world now in Industry 4.0, in a technical world, especially of patents. And now we're in a pandemic crisis, especially it's become more critical for us to learn about the vaccinations, the diagnostic tools, for example, on how to overcome this current crisis. And it all goes back to the base underlying foundation of patents. So how are the needs here when it comes to patents? How are the needs of a scientific and technical industry being sufficiently met through the laws that govern it? So today, as I mentioned before, we have two speakers with us, and please allow me to introduce our panelists. Firstly, Mr. Kandiah. He is the founder and director of KASS International, an established Malaysian intellectual property firm with offices in Malaysia, Singapore, and Indonesia. The firm has been around since 1999 and handles clients from all walks of life, including MNCs, multinational corporations, universities, leading R&D institutions, SMIs, and individual inventors. As a resource person for the World Intellectual Property Organization, WIPO, he has been invited to share his expertise on the IP system in Southeast Asia in countries such as Mongolia, Myanmar, and Bangladesh, for which he was also engaged to draft the regulations and through the Trademarks Act 2009. He has also been a part of various intellectual property related organizations in Malaysia. Amongst other, he was the past president of the Malaysian Intellectual Property Association, NIPA, and Malaysian chapter of AIPPI, a foreign member of the Chartered Institute of Patents at Patent Agents UK, member of American Intellectual Property Law Association, a member of the Asian Patents Attorneys Association, and also INTA, the International Trademark Association. Mr. Kandiah and Dr. Chris are both well-versed, especially in the area of intellectual property and patents, and have been invited to judge several innovation competitions in Malaysia. Okay, moving on to our second speaker, Dr. Chris Hemingway. He is a director of the local office of the Merks & Clerk Group, the largest specialist international firm of patent and trademark attorneys in the world. He specializes in the drafting and prosecution of patent applications, and is one of only few practitioners in the country here in Malaysia who are also qualified as UK or European patent attorneys. He has experience with a broad range of technical subject matters, ranging from mechanical and software-based inventions to medical devices and chemical innovations. Locally, Chris has provided advice throughout and seminars to various entities, including various research universities in Malaysia, Biotech Corp, Genting, Petronas, Mimos, and etc. And he is also a judge for, like I mentioned before, like the annual iTex show. Chris is listed as an expert for Malaysia and Southeast Asia, IPR SME Help Desk, and is or has been a member of the executive committees of MIPA, Malaysian Intellectual Property Association, the International Association for the Protection of Intellectual Property, AIPPI, and the Asian Patent Attorneys Association, for which he has also represented Malaysia on the Patent and Design Committees. He is also a member of the Licensing Executive Society, LES, and the British Malaysian Chamber of Commerce. Okay. Thank you, Dr. Chris and Mr. Kandiah, for joining us for today. And I'd just also like to point out that since we are on MPC platform, Mr. Kandiah was also formerly with MPC from year 1974 to 1982. And he was also one of my earliest mentors in intellectual property during my second year of studies in university. Okay, welcome again to everyone on the platform today for today's webinar. Some ground rules for any questions that you have for today's session to either one of our speakers. You can send the questions. It's best if you can actually also address the questions to who or whom would you like them to be answered to. These questions should be put out in, if you're entering by mobile, you could see a question mark box at the bottom of your screen, or it actually says questions there. So you click on that and then send the questions there and not to the chat box. So you can please send your questions, fill out the details there and your name and also who you want them to be answered by. And if you want access to any of the handouts, you can also click, there's a tab that says handouts on your screen there. You can actually download the handouts that are shared in this seminar today. And if you need to interact with any of the participants, you are welcome to do so via the chat box. But the chat box is not where you put the questions. So without further ado, let's start with a simple overview of intellectual property. So this is also to benefit those who are quite new to intellectual property and who might not be active or who has no prior experience practicing in intellectual property here. So about intellectual property in general, if you can see the screen here. Okay, intellectual property is a part of a bigger picture of intangible assets. Yeah, so intangible assets are the other world of tangible assets. So like we know in the real world, you have real property, things that you can see and touch, generally like buildings, land, real estate, yeah, equipments, machinery. So these are in general form assets that are usually before this quite commonly known to people. But now it's starting to become more and more apparent how important intangible assets is. So it's also studies and also financial records have reported that the importance of intangible assets are becoming more and more apparent, and it's becoming one of the more significant drivers of economies, especially the US and China. So intangible assets can fall within a wide range of items. So it includes non-physical or goodwill. So goodwill is like, you know, McDonald's. So it's not just the name, but what's the goodwill that carries with the brand. Marketing related intangible assets, customer related intangible assets, like we know, customer data is so important. One of the reasons perhaps that was discussed over the acquisition of WhatsApp by Facebook once upon a time. And also we have artistic related intangible assets and contract-based intangible assets. So these are intangible assets according to rights. So if you have licensing rights via licensing agreements or rights to franchise, so these are valuable. These are intangible values, but they're via a contract, so you can't really actually see them, but the value is tremendous. The same thing with WhatsApp once upon a time when Facebook acquired it for a substantial sum. There was no physical asset, but there was a lot of intangible value behind the whole idea of WhatsApp and what it carries with it, especially the customer related data. So under the realm of intangible assets, we have intellectual property. So intellectual properties are basically, in general, people say ideas. yeah, ideas or creations of the mind. But in general, these ideas, artistic and whatnot, are reduced in some form of material form, yeah. So you can actually sort of identify it, and you can sort of like a brand name, yeah. You can sort of see and identify it. So in a way that it is reduced into material form. So that is intellectual property. But under intellectual property, we have so many different types, yeah. If you are within one particular industry, one type of intellectual property might be more familiar to you compared to the others. Like if you see this screen right now, there are like about 8, yeah. But you might be more familiar with the 4 on the left here. Like you have the bigger circles, right? You might have heard of copyrights, patents, trademarks, industrial designs, yeah. And the more less popular type of intellectual properties like integrated circuits, geographical indications, trade secrets, or confidential information, and new plant varieties, yeah. So in a way, you can categorize intellectual properties into registrable and non-registrable IPs. Like the blue ones, there are forms where you can register these IPs and have exclusive ownership over these IPs, whereas the ones in green are generally non-registrable IPs, but there are other ways on how these intellectual properties are being protected. And for those who are quite new here to IP, intellectual property in Malaysia is governed by Malaysia Intellectual Property Corporation, or MIPO. Yeah. So any form of registration of intellectual property or protection thereof is usually submitted through the MIPO. So, and this is just an idea of what IP is, or to the extent of how important IP is. So sometimes when we look at one product, we might have the idea that there might be only a single IP. Maybe it's the design, maybe it's a patent. But actually, when you look at any one product, there are more than one type of IP. And for example, if we look at this this example of this car, right? We could see like there are brands here. And when it comes to the brands, it's in the form of a trademark. You can see that there might be different types of trademarks. Like in Malaysia, through the recent Trademarks Act 2019, we have now recognized further forms of non-traditional marks, which are beyond the traditional marks, like the symbols and the names that we're used to. So for example, you can have more than one trademark on a single product, like here the symbol T, and also the full name or the full version of it, Tesla. And of course, you have different types of copyrights involved in the making of this one item, behind the drafting, the illustrations prior to coming out with this product, especially when they were trying to draft, for example, the patents. And of course, Tesla is known for its electrical ingenuity, and you have patents in that, yeah? So you have maybe not one patent, definitely you have more than one type of patent and segregated throughout the different components of the Tesla engineering. And some parts, if not registered as a patent, it might be protected by way of trade secrets, yeah? And of course, the design of the car itself, as you see, is a form of industrial design where you can also protect that as a separate form of IP. Okay, so as a brief overview, so we already know that there are different types of intellectual properties, yeah? And for today's session, we know that we're only talking about one legislation, that is the Patents Act. Yeah? But to give an idea that there are different types of different legislations involved in intellectual property, like we have the Trademarks Act in 2019 that was just passed, which repealed the former Trademarks Act. And you have the Patents Act, we have Copyrights Acts, Industrial Designs, Geographical Indications, and New Plant Varieties. And amongst all these types of intellectual properties, all of them are actually protected through MIPO, the Intellectual Property Corporation of Malaysia, except for the Protection of New Plant Varieties Act, which falls under the Agriculture Ministry. Yeah. So I think you will all have access to these slides. So what we're talking about for today's session on the Patents Act, we're talking about the technical part of inventions. So patents comes in the form of either a product patent or a process patent. Yeah, and there are different criteria on how you can qualify to get your product registered as a patent. So this is the focus of today's session. And I'd like to actually start by inviting Mr. Kandiah to also share with us brief history of Patents Act.
Thanks, Munirah. Thanks for the kind introduction as well. Well, good morning, ladies and gentlemen, those who are out hearing this or participating in this webinar. Now, the issue of intellectual rights, as Munirah has mentioned, has become very critical in the modern business environment. It used to be a place where at one time where research is done in one place, in one establishment. It is produced there and is marketed from there. Everything was in-house. But now with the globalization of a business, the various aspects of producing a business are isolated and done in probably in different countries as well by different people. So IP is becoming more and more important. For example, we take the case of shoes, Nike shoes, for example. Nike as a company in the US doesn't own any shoe factory. What they concentrate on is on doing the R&D, research and development, and managing the brand and managing the marketing part of it. Now, the R&D they do in the US is protected by way of patents, but the manufacturing is outsourced to countries where the cost of production is lower, probably to Indonesia, to Vietnam, and so on. But they manage the intellectual property aspects. The actual cost of the production is done in different country. So if you take a modern product, okay, any product you take, for example, in the modern products, you find the most important aspect of the product, most high cost of it would be the patents itself, which goes into R&D. For example, if you take a pharmaceutical drug, the cost of production of drug may be just a few cents. Okay? The factory cost producing a tablet may be only a few cents. But the drugs are sold at a much higher price in the marketplace because the company has recovered the R&D cost, which is covered by protected by way of patents. Okay, so if you took any product, for example, you have to look into how you're going to recover the R&D cost. That is covered by way of patent rights. Patent rights, as Munirah explained, these are property rights recognized by the government. And if it's a property right, you have the exclusive right to the property. A comparison would be, for example, if you own a house, you have a title to the house, which is issued by the land office of the government. Okay, that title recognizes the property, identifies the property, the address and the survey details be there, and it also identifies who is the owner of that landed property. So similarly, a Patents Act grant a patent or identify what the technology is covered by the patent, who is the owner of the patent as well, and also identify further details. For example, who are the inventors who created the technology and so on. Okay, that's a simple analogy between the grant of a patent and a landed title for a landed property. Now, talking about the Patents Act in Malaysia, our own Patents Act came into force in the Patents Act of 1983 came into force in 1986, 87. But before that, we were linked up to the UK Patents Act, as most colonial countries had. Before our Patents Act came into force, somebody to obtain a patent has to file a patent application at the UK Patent Office, obtain a patent granted in UK, and then have that granted patent re-registered in Malaysia within 2 years. Okay, once a patent is registered in Malaysia, it was enforceable in Malaysia as though the patent was granted in Malaysia. Okay, Sabah and Sarawak had similar ordinances as well. Okay, but after the new Malaysian Patents Act 1983 came into force, the old act and ordinances have been repealed. So now, if anybody wants to obtain a patent, you no longer have to go to UK to obtain a patent. Everything is obtained. You file in Malaysia, prosecute before the Malaysian Property Office, get the patent granted, and maintain the patent in Malaysia. Okay, so we are no longer linked to the UK system, although there are some relationship between Malaysian Patent Office and UK Patent Office when it comes to examination of the patents. For all practical purposes, you file the application at my IPO, you prosecute the application before my IPO, and then maintain the patent at my IPO. Okay. So that's brief history of the Malaysian patents. I will not go into the details of the ordinances. The ordinances are very simple. It's just that you register a patent in UK, you prosecute in UK, and then you re-register in Malaysia within 2 years after grant in UK. And the patent enforceable in Malaysia, as long as the patent is maintained in the UK, is subsisting in the UK Patent Office. Okay, so you have to pay the annuity fees in the UK Patent Office in order to enjoy patent rights in Malaysia. But as I mentioned earlier, under the new Patents Act, all its old legislation had been repealed. Now everything is done under Malaysian IPO in Malaysia itself. Makes the cost cheaper and convenient for Malaysian researchers and inventors. Okay. Okay. Thank you.
Okay. Thank you, Mr. Kandiah. Yeah. Thank you. Okay. So we now realize, right, how in the past that patents, when it comes to the registration, was quite a complicated back-end process there. And Mr. Kandiah has touched a bit on how it's a bit different now based on the Patents Act as it is today. Dr. Chris, do you want to actually talk a bit on how it has evolved since then, and what are the major changes that we have through the existing Patents Act and the procedures now?
Sure, thanks again also for the introduction. Hello everyone. Yeah, so when the Malaysian Patents Act first came into play, it was primarily based on the UK Act, because that's where most of the, before that, that's where most of the Malaysian applications were coming from. They were extensions of the UK system. So it made sense to base the law on what already was being done. But of course, things develop over time. New technology comes out, new regulations come out. And I think one of the biggest things that has changed over the years is a push for harmonization. So, for example, I think it was in 2007, Malaysia joined the International Patent System, otherwise known as the PCT, the Patent Cooperation Treaty. That means that someone could file an international application. You could have most of the procedures consolidated at an international level, and then you choose to select which countries you want to continue in. And so before that, if someone wanted to go into Malaysia from a foreign-based application, you only had 1 year to decide that. So if you filed, for example, a patent in, if you lived in Japan and you wanted to file a patent in Japan first, you only had 1 year to then file an application in Malaysia. But after joining the international system, you effectively get 2.5 years, and part of the international system is to give you an idea of how good the application is. Does it meet the requirements for patentability, novelty, and inventive step? So once you've got an idea of whether or not it's patentable, you have that reassurance on then choosing Malaysia as someone that would take on that opinion and probably then process it through to grant if that opinion was favourable. So joining the international system actually helps, because if you're looking into Malaysia as somewhere where you wanted to patent something from a foreign perspective, you have greater reassurance that you can get a patent granted more easily after joining the international system. More recently, there have been some regulations which have tried to speed up patent applications. So in 2011, for example, with the most recent regulations that were issued, they tried to shorten the amount of time given to respond to examination reports. And also the deadline for requesting examination was shortened as well. At the moment, if you want to get a patent granted in Malaysia, it might take 5 years. That might sound like quite a long time, but actually that's not that bad compared to a lot of other countries. The fastest countries in the world are still maybe 3 years before you can get a patent granted. There are ways to accelerate these things if you need it, but on average, you're talking several years just because of the processes that they have to go through. And every patent office in the world has a large backlog of applications. Malaysia's, although I'm saying it might take 5 years, actually that's quite respectable when you compare that internationally to other offices. More recently, there's been some discussion of the Trans-Pacific Partnership Agreement. So there was some discussion about trying to bring in some extra regulations to harmonize with that. Of course, then Donald Trump came into became president and decided that he didn't want to do the Trans-Pacific Partnership Agreement anymore. And so people were drafting on those regulations, had to stop, and I think that's all being put on hold. Having said that, there is the comprehensive agreement now, which is based on the remains of the TPPA, which is everyone, I think, getting involved without the US, and that may actually lead to a further revision of the regulations. I don't know exactly when. There is some discussion about it, maybe in the next year or two, possibly, and this will see some changes in the law if it does come through. Actually, I would say Malaysia doesn't have to change its law too much to meet the criteria for the new agreement. A lot of the laws are already compliant with it. There are some additions, for example, to cover for biologics and maybe for post-grant extensions of term beyond the normal 20 years. But other than that, we're mostly already there. And since the regulations were last updated in 2011, and it's been a while since the Act was updated as well, there probably is, now is probably actually a good time to look into that. It's been quite a long time since there's been any changes. Okay, so I'll pass it back to you now.
All right, thank you, Dr. Chris. Okay, so we've seen a lot of changes over the years, and being also with the IP industry, I also realized there's major changes, especially that Maipo has tried to also improve the flow of the processes over the years. So on top of patents, also other types of IP has seen a lot of major changes, so well done to Maipo there. Okay, when we talk about, you mentioned about the TPPA, and now there are subsequent discussions that are taken up from that. How do you feel is the relationship between the stakeholders as well as the government and ministry representatives in taking up these issues relating to IP and patents in particular, and how actively involved are the stakeholders here as well as the industry players in these discussions, and how are these representations or the ideas being brought forward, the comments from the industry players being taken up? So how do you see that? How do you see the relationship between the stakeholders here as well as the government? Can I have both Mr. Kandiah and Dr. Chris to share with us?
I think that's interesting as you should bring it up. One of the common complaints from the industry is that it takes a very long time for a patent to be granted from the date of application. As Dr. Chris mentioned, it takes about 5 to 6 years. That is a very optimistic timeline is given. In practice, it may even take longer. Now, to address this issue, the government has taken up a number of issues. One is that under our patent system, when it comes to the substantive examination of the application, that is before the patent office decides whether the application is filed, whether the invention is novel, inventive, industrially applicable. We have entered into certain arrangements. Our Patents Act recognizes that you can bring the claims in conformity with those granted by 6 other patent offices. We recognize the examination results of the allowed claims in Australia, Japan, the European Patent Office, Korea, and Japan. So if the applicant has filed a corresponding application in any of these 6 jurisdictions, if those countries have examined the application earlier, the applicant can adopt the same claims in Malaysia and have it examined faster in Malaysia. That will speed up the process. The second initiative the government has taken is the patent prosecution highway. That is, the Malaysian Patent Office, the Japanese Patent Office have entered into some agreements whereby the examination of the patent application can be speeded up itself. Okay. These are common arrangements between patent offices to increase to reduce the speed of the pending applications. Okay. I will not go into the details of the patent prosecution highway, but we have bilateral agreements in Malaysia, Japan, and Korea as well. In addition to that, the third one is the aspect that within the ASEAN countries, they also have a certain amount of collaboration and cooperation to reduce the speed of the patent examination as well. Okay, so I would say to reduce the speed of the or to increase the speed of a grant, you can take one of the three ways. One is the where you have filed application corresponding in other 6 countries, namely UK, Australia, Japan, Korea, and the European Patent Office. If those applications are examined earlier, the applicant can choose to adopt the same claims for the pending claims in Malaysia and have the patent application granted earlier. That's one way. The second way is through the patent prosecution highway. The third is through the aspect system. These are 3 modes, okay, or speeding up the grant of application. Okay, thank you.
Thank you, Mr. Kandiah. Dr. Chris, do you have anything to add when it comes to, okay, Mr. Kandiah so enlightened us on how patent application processes have, in a way, been addressed and expedited through other various alternatives, like the PCT, the regional applications, as well as the PPH. Do you feel like, apart from the time taken for patent applications, what other comments or what other engagements are there between the industry players and the other stakeholders in IP with the ministry? And do you feel that there is a good flow of understanding between the ministry and the government, especially when it comes to representing these ideas, this industry in trade negotiations?
I think things have improved over the years from what I've seen. So normally, if there's a suggestion to change the law, I think it's mostly driven by my IPO. And nowadays, we see that public consultations are sent out by my IPO. So, for example, as a member of MIPA, MIPA is probably the main organization for intellectual property practitioners and owners as well. So they will send us a dialogue, and we will normally, the MIPA will normally collate the feedback and then feed it back to my IPO, who will then discuss it, I think, with the ministry. The issue that sometimes comes about is that I think when the people that draft the law then start working on the wording, it sometimes loses something in translation somehow, and the practitioners don't have a direct connection usually to the ministry. It goes through my IPO, and when the practitioner said, well, can we see what the final draft would look like before it's released? The problem is that it's protected under the Official Secrets Act. So as far as I understand it, so we don't get a chance to see it before it goes out, and that's when you sometimes get a few things that have not quite come out correctly, or creates a few complications. So while there is some discussion at the moment via my IPO, what I would like to see to improve the system is maybe MIPA or the other stakeholders can have some direct input with the ministry, maybe on par with my IPO through the organisation, so that we can help guide the legislators as to how the law can be crafted without kind of coming up with loopholes that cause complications later on. And I mean, going back to what Mr. Kandiah was saying, I mean, I hope that they do maintain the modified examination system, the one where you can base a grant of an application on a foreign granted patent, because actually Malaysia is way ahead of anyone else in the world on that point. I think there's only Singapore that currently does that, and they're actually going to be phasing it out soon for reasons that are up to themselves. And I think maybe somewhere maybe Iran or somewhere like that has it as well. But other than that, Malaysia is really the only place that does it. And I think it's a really good way of speeding up the system, and should be maintained. So I hope, when it comes to the next revision of the Act, if there is some discussion about phasing out like Singapore that's done. I hope that we get the chance to say, actually, we think it's the right to maintain it is the better direction, because actually with a lot of these other systems there's a push towards harmonization, because it makes, if you're an applicant, you want really to be able to submit one application and have it examined in more or less the same way in every country, because if you get a positive outcome in one country, you can usually use that as a basis for all the others. It gets very confusing where you can do something in one country but you can't do it in another, or a third country has completely different rules. I don't know if we'll have time to talk about that later, but certainly some of the things that have happened in the US recently have conflicted with what's happening in Europe, for example. And that makes everyone's lives a bit more difficult, I think. Okay, back to you.
Okay, thank you. Okay, so all right, that's great to know that we have actually quite a good interrelationship between the industry here as well as MAEPO. It's just that perhaps when it comes to patents in particular, the representation or the comments were not taken or reflected accurately at the stage of drafting, because there has been some sort of dilution. Yeah. Okay. We also talked about harmonization. You mentioned about harmonization. So there are some pros and cons in that, and there's more discussions that needs to happen when it comes to harmonization. Okay. Coming back to Malaysia. Okay, we have an IP court. So several years ago, an intellectual property court has been established to actually assist with IP matters that tends to be sort of technical in a way. How far do you think that the establishment of the IP court has supported the evolution of IP, in particular when it comes to patent disputes and patent applications? Do you see that the IP court has been able to support the resolution of the disputes as well as the law surrounding patents itself? Maybe Dr. Chris first, and then Mr. Kandiah.
So I think it's really good that there's a dedicated court in Malaysia for IP, and actually if you want to get a resolution in Malaysia for a patent case, it's normally within 12 to 18 months, and that's pretty fast actually. That's on par with Singapore and most of the developed countries, I think. If you look at some of the other countries in the region, you're looking at maybe 5 years before you get to court. It's a lot longer. So Malaysia again is very fast on an international level compared to a lot of the other countries. It generally follows the UK law, which is good. There's a lot of stuff that comes out of the UK that can be used as guidance for the judges here. I sometimes feel some of the decisions, how can I put this, they might need a bit more assistance. I think there's it would be good if there was some further training, particularly on the technical side for judges, because a lot of the judges aren't technically qualified. There is rotation that happens quite fast with the judges as well. They usually only last for a few years and then they move to a different position. And it's difficult, I think, to build up knowledge in IP over a short time. You need several years of experience, preferably all in the same court. That's why having a dedicated court is useful, because at least it's the same judge always dealing with IP cases. If you look at America, they have a judge who will be looking at a car crash in the morning, a murder in the afternoon, and then talking about IP, and they just don't have the knowledge. Yeah. So, we follow much more like the UK, which is good, but as I say, it could be improved. And hopefully, I think one of the things that Singapore does, for example, that has really helped is they invite judges from the UK and some other places to come and give sessions and training to the judges in Singapore to help build up the judges' knowledge, so that the decisions are more accurate and reflect how the law works. So I think it's good where it is at the moment, but I think there's also room for improvement.
Okay, Mr. Kandiah.
Just adding to what Dr. Chris mentioned, the IP court handles all areas of IP rights, copyrights, trademarks, patents, and so on. I've appeared before the IP court in a number of disputes. As far as trademarks and copyright are concerned, the judges need not have technical knowledge. They can handle the case very well. When it comes to patents, as Dr. Chris mentioned, the judges do not have a technical background. And normally the court is guided by the evidence given by experts brought in by both the plaintiffs and the defendants. But sometimes technology involved may be very complex. The judges may not be able to understand. Of course, it's a duty of the litigants to explain to the court as simple as they can what's the technology all about. Okay. So here the court could be assisted if it could get a guidance of technical experts assisting the judge on some of the highly complex technical matters. Okay. I remember I did a case on something like the oil rigs and oil wells, where the applicants brought in the graphics and simple models to explain to the court what is the inventions all about, what was the prior art, where was the invention, and what is patentable about their new invention. So some technical experts would help the court or help the judge to come to decisions as to what is the dispute is all about. Okay. So IP court, the patents court can be improved if there are technical assistance, technical experts in the court to assist a judge. Okay. Although their opinions and decisions may not binding on the court, but it will greatly assist the judge. Okay. You only need it for patents for patent litigation, but for trademarks and copyright, you don't need that. Okay. It may help if the dispute is on patents or on industrial designs. Okay. Thank you.
Yeah, thank you. So based on the feedback on the two questions earlier on the stakeholder relationships between the government and the industry players, as well as in relation to how supportive has the dedicated IP court. So we call it dedicated instead of a specialized IP court. So how has these this sort of improved, assisted the IP laws in a way? Yeah. So
well, increases the speed of disposal of a case, but it's only one IP court in the country that's based in Kuala Lumpur. Okay? But the other disputes on trademarks or on copyright, they are normally filed at the various state courts and settled there. But if it's a patent matter, it's better to be filed in the KL court because we have a dedicated IP court in Malaysia. As Dr. Chris mentioned, if the judges can stay a bit longer on the bench in KL High Court, then it'll help to speed up the case better. But they very often, after 2 or 3 years, they move on to different positions and start all over again.
So there are two aspects here. The technical knowledge of the officers as well as the judges in the IP courts might assist further the industry, particularly because of the rotation system that exists. So maybe if the dedicated IP court were either to have a prolonged judge sitting at the bench there, or either they would have on top of that continuous knowledge or sharing of the different aspects of a technical knowledge. Because, like, for example, Dr. Chris, you have a PhD in microbiology, and Mr. Kandiah, you have both a bachelor's in science as well as a bachelor's in laws. So when it comes to patents, for example, there's different types of inventions and innovations out there. So it crosses
I think
mechanical engineering, electrical engineering, whatnot.
The court require technical in different fields. It could be a pharmaceutical product based on chemistry, or it could be an engineering product, for example, or it could be an electronics product. So the judge will need assistance from experts from different technological backgrounds. He can't be an expert, or he can't have knowledge in all different fields of technology himself.
So it's important that the government actually considers taking up the right experts on board with them at the stage of final drafting, perhaps, of legislations or even negotiations of IP-related matters, especially when it comes to patents and when it comes to dedicated IP courts. Maybe having the rightly equipped officers in the IP court to support the judges there. Yeah. Okay,
you could have an IP judge. What you need is the court assistance of technical experts to assist the judge in deciding on highly complex technical matters.
Agree. Okay. Yeah. I think if there is any participants from the MIPO, the IP industry, I think many of you would be able to agree on with Mr. Kandiah and Dr. Chris here. Okay, that's great. Okay, thank you for that input. Moving on, when we talk about patents, so now when we go into the pandemic that we have right now, COVID-19. So there's various talks about when is the vaccination coming out, what are the diagnostic tools. There's a lot of different innovations that are coming out to actually assist businesses as well as the health sector. And when we talk about patents, the underlying rights to these kind of innovations, one of the fear of many governments is the monopoly. Right, and patents in a way is also labeled as a way of legalizing greed of profits. So how, what's your views here when it comes to this idea of monopoly through patents over a product or a process? What are your views here, and when it comes to balancing that with public health driven R&D? So Dr. Chris, do you want to give your views first?
Yeah, this is always a tricky question because obviously an investor wants to recoup their investment, the costs that they've spent in developing something. But at the same time, what about public health? You don't want to have something which is so expensive that no one can afford it. And actually the Malaysian Patents Act does provide for that. And Malaysia has also used this provision in the past. If there is a public health crisis, you can obtain a compulsory license of a patent. So, I mean, one thing to say, let's say the US develops a vaccine or China develops a vaccine. The first thing they would have to do to exert their monopoly in Malaysia is file a patent in Malaysia anyway. Maybe they choose not to. I mean, that's one possibility. But even if they do, if the supply is not sufficient, and there's a few things here, a few reasons which are allowed here, but one is if the supply is not sufficient, or excuse me, or I think if it's considered to be too expensive, the government can step in and order that they license it to I think it's to a local manufacturer, so that the vaccine can be produced at a lower level. And because a patent has to contain enough information to recreate an invention, that should be possible. It shouldn't be possible to do something, have a patent where there's a secret ingredient, for example. I forget the name of the drug where they did it in Malaysia previously, but it has been done before. So, and who knows, that might happen in this case because it is a pandemic. I don't know if Mr. Kandiah has any views on this.
Thanks for Chris. I think to go back to the basics, the patent, as Munirah mentioned, but the patent system itself is based on the basis that you disclose the details of the invention. In return, you get the exclusive right to invention for a limited period of time. That's the fundamentals of patent law. Now the question is, who the patentee abuse that monopoly right or exclusive rights? This is where the price issue comes in, whether he's selling at a price which the public cannot afford and things like that. There's a certain amount of abuse, but there are safeguards to prevent this abuse itself. Dr. Chris mentioned the government retains a right to grant compulsory license to use that technology there. It could either give a license to somebody else to manufacture the product if they have the capacity, or even to give somebody the right to import a product from another country and sell it at a lower price in Malaysia to meet their local demands. So these are safeguards built into the system itself. As Dr. Chris mentioned, Malaysia has used this compulsory licensing provision earlier for some other drugs as well. And most countries have this. Even the US has attempted once to use the compulsory licensing provision in their act when there was an outbreak of anthrax a couple of years ago. Okay. Now, I think in order to, before the talk about compulsory licensing, there must be also
hepatitis C drugs.
There must be a patent granted in Malaysia. Only then we talk about compulsory licensing. But if there's no patent granted in Malaysia, it takes a long-term patent to be granted, then there's no exclusive rights, and anybody can bring the drugs for the vaccine or from some other country and sell it in Malaysia. They can do it until the patent is granted. Okay.
Okay. Thank you. Yeah, very clear. Okay. Okay. The next issue when we talk about monopoly, when we look at current medicines and treatments and medicines and hospital, the prices relating to these increase every year, and that's why insurance in a way is very expensive, right? So coming into patents, and where pharmaceutical also relies on patents extensively, and the cost there to protect pharmaceutical drugs. And most of these pharmaceutical drugs and treatments are widely influenced by Western culture in a way. And again, there is a big, because it's widely influenced there, there's sort of a monopoly, we could say, on what kind of treatments or drugs are recognized. What are your views when it comes to the possibility of protecting or also introducing and repackaging alternative treatments and drugs? Like, for example, we live in ASEAN and Asia. We have various types of alternative remedies and treatments, and some have worked. It's the same as well in a way when we compare it to Western medicine. And even if you go to surgery, it's not 100% guaranteed that you get full recovery. So the same thing with these alternatives. Is there a way that we can sort of promote Asia or ASEAN treatments or drugs as as a pharmaceutical industry in itself, to be in comparison with the Western ideology of medicines and treatment?
The Western ideology of protecting drugs is based on a system where the researcher comes out with a particular chemical molecule or chemical composition, and then it is formulated into a tablet or some drug, and then is introduced to the human being, and exclusive rights to the product itself. Under the patent law, you find that it's got to be novel, it must be inventive and industry applicable. The industry applicability is almost granted. It's a novelty and inventiveness that matters. Because at the time when you file the application, there's no requirement that you show that it actually cures the particular symptom. You need to show some lab results, and it works on animals and is extrapolated. It works on mammals, in the rats and guinea pigs. It will work for man. You need not show actual evidence of use on human beings before you get a patent. That's for the regulatory body, which grants market approval to see the clinical trials and whether it works on human beings. There are side effects. The Patent Act doesn't deal with that aspect of the pharmaceutical product. Now, when it comes to the traditional cures in Asian countries, you mentioned about jamu and various other things. Well, you try to get a patent on these formulations. It may not satisfy the patents law. Firstly, if these remedies have been used for a long time, by definition, they are no longer novel. Therefore, it will not even meet the first criteria of patentability. So maybe we should have a specific act itself, a sui generis act, a specific act to deal with type of traditional medicine, traditional cures. It's not only jamu, a lot of other things. Ayurvedic medicine from India, for example, they've been used for hundreds of years. Now, if you want to get patent rights based on the existing patent, or you want to get exclusive rights to that treatment based on the existing patent laws, it's not possible because it's no longer novel. It does not meet the patentability criteria itself. So we need a very specific act, another act itself, to grant exclusive rights to traditional medicines. But it raises a lot of other issues. Who will own the right? Because normally traditional medicines is by a community itself, not by a single individual practitioner. So these are issues the new law has to attend to.
Okay. Very good response. Thank you, Mr. Kandiah. Now, Dr. Chris, do you want to weigh in on this?
So, yeah, this is quite a thorny issue for developing countries in particular. There is a thing called the Nagoya Protocol, which is something that's been in development for a long time to try and help tracking of traditional knowledge type information. As Mr. Kandiah says, a patent is not very practical. And sometimes there's a conflict as well, and a lot of misunderstandings that can arise from it. The Nagoya Protocol is really there to try and track resources as they come from a country. But there's a lot of issues with it. It doesn't quite work at the moment. I think there's a lot of burden on the researchers, and the things that are tracked aren't very practical to track either. It's very difficult to actually implement. So I don't think it's in a practical state at the moment for most countries. Where the issues arise is and I'll give you an example, is where the Tonka Ali published stuff that was published last year. A patent was granted actually in the name of the government, so the government owns the patent, at least partly does, for what was reported as Tonka Ali. And a lot of people then got very upset because it said, well, you can't patent Tonka Ali because it's traditional knowledge. It's been around for a long time. Everyone knows it's used for treating impotence. But actually, when you look carefully at the patent, it wasn't for Tonka Ali exactly. It was for a very specific extract of Tonka Ali. They've isolated the protein. And it's always been acceptable to patent an isolated protein from a general material. And so to infringe that patent, which is really where people would be concerned, you'd have to use the same method and isolate the same protein, which you don't do in a traditional way. You don't use HPLC to under traditional knowledge. You don't use high performance liquid chromatography to isolate the protein. And so my feeling is that there was a lot of hoo-ha last year about this, but actually it wasn't appropriate. It was misreported to some extent, and this is where patents can sometimes get into trouble, because it's people feel like it's the pharmaceuticals are all trying to get a monopoly on things that they don't necessarily own. But actually, while there is a certain amount of they try to extend their monopolies to some extent, even this process which some people refer to as evergreening. You can't, let's say you isolate a protein or you make a new vaccine or something like that, that has a limit of 20 years. Even if you then you can't extend that 20 years. There's no way of extending that in Malaysia. You might develop a new method of 5 years later. You might develop a new improved method of making that vaccine. But that doesn't stop you making someone else making it the original way. So once that first patent has expired, even if the second patent is now going and it's shifted on a bit, while a third party wouldn't be able to make the vaccine using the new method, you should be able to do it, make it using the original method once that patent has expired. So when people talk about evergreening, it's a bit of a misnomer. I think there are some developments to help improve things, but they don't necessarily they don't extend the term of the original patent. So I was trying to think of a different phrase. I'll see if I can think of a better word than evergreening, because I think that's not quite the right word to use for this type of process.
Well, I think to the extent further what we said, when you talk about pharmaceutical products, there's more than one type of issues the pharmaceutical firms handle. One is the active molecule itself, or the composition. Then you also have issues of various salt forms, various derivatives of that active molecule. Now, if it shows some improvements, better efficacy, then it's possible to obtain a patent for the derivative of that active molecule. This area of controversy, especially in India, where they found an Indian firm pharmacies, look, if I have active molecule, it's quite obvious. I know what derivatives will work better and so on. There's a lot of research goes on there. So Indian government said that's evergreening of patents. But as Dr. Chris said, even if you have come with a new drug, derivative of the drug, you still have to establish it's novel and inventive. The second criteria may be difficult to satisfy. So the standards are there. It's a question of at what level do you raise a bar too high or not. These issues look at that. Then the other thing, something just slipped my mind. Okay. So evergreening, then what about method of delivery of the drug itself? Okay. Normally we try to take one drug one in the morning, one in the afternoon, one in the evening. That's inconvenient. So you can come up with a formulation, a varied formulation where the patient only takes one drug a day or once a week. This will be improvements, and that can be patented, but it doesn't deprive of the patient of the earlier patent which may have expired, for example. So expired patents are coming in the public domain, and anybody can use the technology disclosure to make the drug. It's only the improvements which is covered by patents, and you can't go on to the improvements.
Yeah, these are
sometimes. Thank you.
I was going to say
the human body doesn't. The human body doesn't change much. So even if the patent is expired, but the drug may still be good enough for treating the disease, or maybe not as convenient as a modern drug is, where you take one a day or once a week. Okay.
So I was going to say some of the dosage regimes that Mr. Kandiah is referring to, as which is they usually come out a long time after the original patent to try and get an extra 20 years for that particular system, a way of treatment. But actually, a lot of them now are being revoked. So even if they do get granted, the courts are now seem to be moving against them. So even if they've been granted, they're not necessarily valid. So it's becoming more difficult to extend some protection in that way over a drug.
There could be some minor improvements to try to take protection, that being struck down by the courts now.
Okay. All right. In Malaysia, we have in 2016, we have a Traditional and Complete Medicine Act, but then again, that's very local. So if we were trying to package, then I think looking at Nagoya Protocol, there might be different parties lobbying other sectors to protect their own industry. So that might be quite difficult in the long run. It's slippery slope, I feel. But do you think that there might be it might be more possible if Asia or ASEAN were to collaborate in a way and come together to establish a separate act towards packaging these traditional medicines and whatnot. Did you hear me? Hello. Did you manage to hear my question earlier?
Yes, but
No?
I think maybe different countries will get together and maybe some form of international cooperation need to be handled, and maybe WIPO, the World Intellectual Organization, to maybe step in to see if we could have a common ground to how do you protect traditional knowledge for pharmaceutical products.
Okay. Dr. Chris, can you hear me? Mr. Kandiah, can you hear me?
Yeah. You broke up a bit just then, but I mean, I agree with you. I think working together as a region and sharing the knowledge is a good way to do it, because most of the countries in ASEAN are in a similar position in terms of traditional knowledge. They all have some which would be desirable to protect. So ASEAN or through WIPO, as Mr. Kandiah suggests, would be a good way to move that forward, I think.
Okay, thank you so much. Okay, before I move on to some of the questions from the participants, would you give your own views, like respectively, Dr. Chris and Mr. Kandiah, like what are some important areas in patents or IP in general that you feel that might help towards the industry, especially when it's legislation based or regulation based? What areas that can be improved apart from the ones that I already mentioned, involvement of technical experts with the judiciary, as well as the last stage of drafting? So is there any additional comments that you'd like to give on that?
Well, I have 2 points. One is that there's a general misconception in the industry that getting a patent is very expensive. And what's the issue of opening a patent and somebody easily infringes? Now, these are wrong misconceptions. Firstly, if getting a patent is not that expensive, especially it's done by Malaysian firms. Of course, at one time to draft a patent, there are not enough local experts. So the patent drafting was done either in the UK or in Australia. Then you pay a very high price. Now most patents, in most fields of technology, there are adequate patent drafters in Malaysia. It can be done in Malaysia at affordable cost. But if you compare the cost of obtaining a patent compared to the research and development, money you spend in research and development, is a very small amount. Okay, so it is something that's reasonable and affordable by most Malaysian companies. We have individual inventors who spend their own pocket money to file patents. Okay, so it's not that expensive. That's the first thing. The second issue I'd like to mention is where MIPO can take it up is to have amend the legislation to have pre-grant and post-grant opposition. Now, to invalidate the patent, once a patent is granted, to invalidate the patent, a person is interested in invalidating it, has to file an application in court and goes to the legal process. That can be an expensive process. So if the act is mandated, we could have a pre-grant opposition. Once the patent office accepts a patent, it can be published before it's registered, and any member of the public can oppose. So opposition can take place before the MIPO office. And if it is granted, instead of going to court to invalidate it, you can actually file invalidation petition before the MIPO. And any decisions from there can be appealed to the court. So this will reduce the cost of invalidating a patent. These are some suggestions we should look into the amendments to the Patents Act. Okay, thank you.
Dr. Chris, thank you, Mr. Kandiah.
So I think what I would suggest is probably some more investment in my IPO. I think the government needs to put some more money towards it. I think they really do need more people, more examiners in particular on the patent side to help reduce the backlog that's there. So although Malaysia is not too bad, I think they have around 80 examiners at the moment. Probably need close to double that ideally. So if that was possible, I hope that can be looked at. The IT system was completely changed about a year and a half ago. They've been having a lot of difficulties with that ever since. They were having regular meetings last year to try and address a lot of the issues. I mean, I think one of the initial problems was that there wasn't a lot of industry consultation before it was launched. I think perhaps if there had been, maybe some of those issues would have been addressed beforehand. And I know that they are now looking at resolving the issues, but I think, if I'm not mistaken, MIPO as an organisation collated more than 100 general issues when it was launched, and it's maybe I think they've dealt with more than half of them now, but there's still quite a large number left. And I think everyone working from home now, of course we now have to use the online system a lot more, and I think some of the problems that come out are being highlighted even more so at the moment. Moving to resolve those IT issues as soon as possible would be another thing for everyone to look at on that side. I think in terms, there's lots of little bits and pieces in the law that could be dealt with, but it gets very technical. So I don't think we've already. I think Mr. Kandiah has already highlighted one of the main ones. There's a few others that we've talked about already. The rest would be in the consultation as we go along, I think. So I don't think we need to necessarily highlight anything else at this point, unless anyone else particularly wants to talk about them. Okay.
Thank you. Okay. I'm going to take up a few questions that have been raised here. One of the first questions, I didn't actually get the name of the person who asked here somehow, but okay, the question is, one hurdle is to get an invention patented. The other is finding interested investors for commercialization. How would you evaluate and advise a client with an invention? Are the legal firms in coordination with funding agencies? Mr. Kandiah, do you want to answer this?
No, that's a different field of practice. That's a different field of practice. As patent agents or patent attorneys, our concentration is basically get the best form of protection for the invention at hand. Now, when it comes to commercialization, a lot of other issues involved. You need a business plan, and where's your market, what are the substitute products, competing products, and so on. That's not our forte. But what we do is, at least in my firm, we put them to other specific consultants who have expertise and experience in this field, and they'll be able to guide the inventor or the patent holder how to take the product to the marketplace. Okay. We don't do it ourselves, but we have contacts with network of other consultants who do this type of jobs. Okay. But also the inventor can on his own can do a lot of things. He can do a search on the patent brief, find out who are the other players, we can write to them and so on. But it's a different field, we guide them. But when it comes to commercializing invention in Malaysia, we can just guide them, but we don't do it ourselves. Thank you.
Dr. Chris, is there anything you want to add on that?
I think one thing I've noticed over the years is with the universities in particular, because of the government funding cuts a few years ago, there was a shift towards commercialization, encouraging the inventors themselves to commercialize their own inventions. I think both myself and Mr. Kandiah, when we're judging the shows like ITEX, the big innovation shows which people attend, one of the questions we have to judge them on as when we're reviewing them is, have they got IP? Have they filed a patent application or something like that? And then have they also considered how to commercialize it? What stage are they at? Is it just a laboratory project still, or have they started scaling up? Have they thought about the branding as well? So the universities in particular, I've noticed, have shifted more towards starting to think about commercialization more these days, and I think that's actually the right direction for them to do it. Really, the inventors aren't necessarily the best people to run businesses because they tend to be more on the technical side. Having said that, some are very good, but they are usually the first people to start off with that way. And teaming up with an investor is usually the way to do it. The investor usually has the business background with it. But the first question the investor normally asks is, well, how are you going to protect my investment? And that's why you need the patent application. You see, so this is where we spend a lot of time talking to the universities and explaining the reason that why we exist, why you need a good patent application. Anyone can draft a patent application in theory, but it's very difficult to get right. And that's why you need someone experienced who can do a proper job, because if you just hire the cheapest person or do it yourself, you won't get a decent patent and you won't attract an investor if they know what they're talking about. As a long-term solution, you need to make sure that you get it right from the outside, because if you just do something yourself and then it goes wrong later, it'll be too late to correct it. Okay.
Agreed.
Maybe I can just share one experience. We had handled one matter where a patent was granted in Malaysia, and the patentee wanted to commercialize it, no takers. When I looked at the patent document, I said nobody will infringe his patent because it's talking about lab scale, test tube scale, 5 grams of ingredient A, 3.5 grams of ingredient B, and add distilled water, and it's heated temperature of 37.25 degrees and so on. And that was a claims in the patent. So I said nobody's going to infringe his patent unless some lab assistant does it. But when it comes to commercial scale, you're not talking about those value systems. So a patent should be drafted, as Dr. Chris emphasized, must be drafted in such a patent claims be drafted in such a way that they are infringed. If a claim cannot be infringed, then you have no right to take action against people who copy or adopt your invention. So that is very critical. That's why you need to have an experienced drafter to make sure the claims are strong. You can describe whatever in the description, but the claims is what really matters. And that got to withstand an attack in the court, and it might be something that third party will likely to infringe. If a claim cannot be infringed, there's no point in having a patent. You have disclosed the invention to the public. So the drafting skills are very important to make sure that the invention is clearly identified and the claims are properly drafted so that they can withstand any attack subsequently in a court of law and so on if the patent is challenged. Okay.
Okay. Agree. Yeah, so I hope that answers the question. I'm sorry, somehow I can't identify the name from the question box earlier. But to also address the question here, how do you evaluate and advise the client with invention? So apart from what Dr. Chris and Mr. Kandiah has mentioned, like we don't particularly advise with funding agencies, but a lot of practitioners, especially lawyers, sort of have a relationship with certain platforms, like Dr. Chris and Mr. Kandiah are judges with ITEX, for example, and they are also close with Ministry of Science and Technology. So when it comes to IP, it's not just the ministry that regulates MIPO, for example, but it also crosses several ministries, including MITI and MOSTI, for example. Here, when it comes for me as an IP lawyer, it is true, it is very important. Yes, like Mr. Kandiah pointed out, how important drafting is, because there are different terms used, so it has to be strong enough to withstand any sort of possible objections from the MIPO itself or from external parties. And when it comes to commercialization for us, and for myself as a lawyer in IP, we tend to assist clients when it comes to structuring, but it is also very important for investors as well as inventors to consider structuring the intellectual properties earlier on, partly when you know that the timeline for registration for patents, for example, takes years. Yeah, so it's very important for you to consider these timelines in structuring your commercialization structure of processes, and this is what a lot of the MNCs do back end, and then go on into what kind of commercialization process. So for myself, being an IP lawyer, we tend to do that a lot with research universities and research institutes. For evaluation of inventions or IPs, in Malaysia, MIPO actually set out the IP financing scheme way back in 2014. And through that, a pool of intellectual property valuers were also certified. So myself, among with my fellow IP valuers, we have a team of 23, all of us in Malaysia so far. And most of us are now gathered on the platform of the Royal Institution of Surveyors Malaysia. So if you need any assistance when it comes to IP valuation, we have a local pool of talents that is able to assist with IP valuation. So I hope that answers that question. And another one from Dennis Tan. Dennis Tan asked, okay, Germany, Japan, and China has benefited from the utility model protection. What do you think of Malaysia's utility innovation? Who would want to take that up? Mr. Kandiah?
Oh, thank you. Now, we have under the Patents Act two forms of grants. One is a regular patent, where to obtain a regular patent, the invention must satisfy three criteria. Firstly, the features claim must be new or novel throughout the world. Secondly, it must be inventive. And lastly, industrial applicability. Now, we have another form of grant under the Patents Act, which is known as Certificate of Utility Innovation. Now, to obtain this grant, the applicant has only to satisfy that the invention the features claimed are novel, even though it may not be inventive. So minor improvements to existing products and processes, products can be claimed under utility innovation. It's a lower form of protection, but unlike other countries, the duration of protection of utility certificate utility model is still 20 years on date of grant. It's broken up into 10 years, 5 years, 5 years. Okay, it's first grant for 10 years, and then extended for another 2 terms of 5 years each. So total duration is 20 years. In other countries, they give shorter duration of protection. Okay, so that's useful for simple improvements. Okay, the other issue is that we need to look at details. Should this patent application or patent application for utility innovation, they are also examined for substantively. Now, some countries do not examine the utility innovation, or they call it as petty patents or small patents. or substantial. They don't only satisfy whether it's novel or not, and they grant a patent. And anybody wants to challenge this patent, they will then have to get it examined substantially. So there are different models available. But I think we need to relook at how we grant rights for certification, which is innovation. Should it follow the same route as a regular patent, or should we have a different route itself? Okay.
Okay, thank you. All right. Another question, hold on, yeah. Okay. Okay, I'm having some slight, okay. One other question here, I'll direct this question maybe to Dr. Chris. He asks, he or she asks, I'm sorry, I somehow am not able to actually get the names out to point out who the question comes from, except for Dennis just now. Okay, this question is, the cost of getting IP protection may be perceived by many SMEs as exceeding the potential benefits to be obtained from protection, particularly considering that a significant part of the costs may be incurred before the product has reached the market, and that lenders, investors, or government programs rarely provide financial support for the protection of IP rights. What is your views on this?
So I think what I tend to tell people is if it's not worth protecting, then it's not worth patenting. If you're not going to make money from it, I mean, the whole point of a patent is to protect your market. There have been examples, certainly, where people have come up with ideas which are just not going to sell it very well at all. I remember a particular idea once, which was on a TV program, where an inventor had come up with a shower head holder for when people didn't have a shower head holder in their hotel room. And the investors asked her how much it had cost her to patent it, and she said, well, I spent something like £50,000. That's about 250,000 ringgit on patenting in lots of countries over the last few years. And they said, well, how many have you sold? And she said 9. So, you know, it clearly wasn't worth her spending this money because there was no market for her invention. But then on the other side, if you look at like a pharmaceutical drug, you know, these are multi-million pound, they make multi-million pound or multi-million ringgit profits out of these things. So it's clearly in their interests to try and protect their inventions. Of course, we're, you know, normally there's things that most inventions fall in between. You never really know how big your market is going to be it's true that one of the drawbacks of the patent system is that you have to pay to draft the application and to file the application from the outset, and then you have to request examination before you find out if it's patentable or not. But this is perhaps one reason for not accelerating things too much. People will say, oh, it takes so long to get a patent, it takes 5 or 6 years. Well, that's true, but that means your costs are also spread out over that time. If you wanted to get that patent very quickly, your costs would be compressed. And with the way that the patent system works, you're always paying for the next amount of time. So that initial application gives you a year or a year and a half in Malaysia before you need to take the next step of requesting examination. Then it might be a few years before you get the examination report. Well, if at that point you just, you know, before examination, what sometimes happens is people say, you know what, it's not worth pursuing this anymore. We're not going to pay to continue this any further. And they drop it at that point. So there's always a balance with these things. And I think it's probably about right at the moment. It's, you know, the patents in Malaysia are certainly not as expensive as other countries. If you wanted to draft a patent in the UK, you're probably looking at 20 or 25,000 ringgit. In Singapore, it's not far off that either. It's probably 15 to 20,000 ringgit to draft a patent, whereas in Malaysia, it's usually less than 10, sometimes as low as 5, maybe even less than if you can negotiate a good deal. But while that might seem high, as I said, you need to consider why you're patenting and whether it's worth protecting the invention. If it's going to be, if your invention's worth protecting your industry, if your industry is worth 100,000 ringgit or more, it's worth doing, obviously.
I think also to just add into this, when you asked here, what's the cost of getting IP protection may be perceived as exceeding the potential benefits. So Okay, I always like to give this analogy. It's not just regarding patents per se, but in general, any type of IP. So if you feel that there is value to your intellectual property, be it a trademark or a patent, copyrights or whatnot, you need to give some level of protection to it, even though you might not go directly through a patent application, for example. So it's like you have a house, but you don't actually secure the house. So you let anyone in. So if that is how you treat your value of intellectual property, then be it, yeah, but there's no protection there. So that's why there is access to registration. For example, like trademarks, it doesn't cost more than 2,000 ringgit if you do direct registration with MyIpo. And if you need the assistance with IP agents, trademark agents as well, it's not that expensive. And again, for trademarks, last for 10 years. So you distribute that amount over the timeline that you have exclusivity over that type of intellectual property. So from my point of view, I feel that it's important for you to actually do some sort of protection, even though not all types of IP protection. So if you can't do patent application yet, for example, then you need to secure it in a way, perhaps by trade secrets and copyright back and writings or illustrations, so that you have resort to that if there is any sort of dispute in a way. Okay, I'll move on to the next question here. The patent registration process will take roughly 5 years. What is the process or requirements that makes it so long, and how does other countries how long do we compare with other countries? So I think, Dr. Chris, you've already mentioned this, that Malaysia takes roughly around 5 years, and Mr. Kandiah added that this timeline actually is an average. It might take longer, but in general, Malaysia has actually a good record compared to a lot of other countries, and we're sort of at par with developing countries. Maybe Mr. Kandiah, you want to just briefly touch on this again?
Oh yeah, we mentioned this before. Earlier, I think for 5-6 years is average. It's very reasonable.
Yeah.
Now in the US, it depends what field of technology you're looking at. If it is simple mechanical inventions, then you can get earlier examination as a grant. If it is complex area of technology, electronics, or in a pharmaceutical product, that it may take longer. The same thing in the US. Mechanical inventions in the US are granted within 3-4 years, is rapidly granted. But we are dealing with biotechnology itself. Stem cell technology and so on may take 5, 6, or even longer. Depends area of technology. So, but in the US, they have 6,000 patent examiners in the US Patent Office, and they can examine much faster. So if the same applicant file a corresponding application in the US, then that applicant is likely to be examined faster in the US than in Malaysia. And as mentioned earlier, he can adopt the same claims in Malaysia once a US application has been examined and allowed. Okay. So I think various countries around the world are looking at various measures to reduce this time period. Okay. I mentioned about the patent prosecution highway. In ASEAN countries, you have the SPAC. Then you also have these modified substantive examination, where you recognize the grants of a granted patent in another country. In Malaysia, we recognize we accept the search results issued by 6 jurisdictions, namely Australia, UK, Europe, Japan, and Korea.
Okay. All right. I hope that answers the question. Thank you. Okay. One of the next questions is trade secret explicitly protected in Malaysia, and does trade secret offer a better protection than what patent does? Okay, this is very subjective. Dr. Chris, do you want to respond to this?
That's probably a question for you, I think, Munirah. If you want to do all that.
Okay. Well, basically, trade secret is not explicitly protected in a way that there's no act, there's no legislation, and that's why it's called trade secrets. Yeah. Maybe in some countries they sort of have some guidelines towards it. Internationally as well, they have guidelines, and it's open for these countries whether they want to have a regulation. But ultimately a trade secret, or in some countries they refer it to as confidential information. It leaves each inventor or each IP proprietor to protect these trade secrets. So that's why strategizing is so important. Trade secret is often done, especially in pharmaceutical industries, before they go into applications, before they submit it for a patent application, because as you rightly know, it takes a certain amount of time for patents to be granted, and therefore, let's say in Malaysia we have 20 years. So if that patent application takes about 6 years, for example, then you only are left with about 14 years to commercialize the drug. So that's why commercialization is so important. Then you have a right in the market for that remaining number of years. So before that, what usually happens is some of these industries protect their inventions by way of trade secrets. There's different methods. Some actually segregate different parts of their R&D teams. For example, like team 1 would be involved in one aspect or one component, whereas team 2, and this is very common in engineering patents or engineering kind of inventions. Segregation of teams, access to laboratories, the amount of people involved in certain R&D. So there's different methods on how a trade secret is protected, and it's not just by a non-disclosure agreement. So in a way, there's no regulation in Malaysia or legislation to that governs trade secrets. It's often based on industry, what is more effective for a certain industry. Okay, I hope that answers that. Mr. Kandiah, do you want to add anything on that?
Yeah, 2 points. Firstly, for government secrets, you have the Official Secrets Act. That's for government secrets. For industry, for secrets in the private sector or non-government sector, trade secrets are protected under common law. We don't have a very specific Trade Secrets Act in Malaysia, although some countries do have. We don't have specific act for trade secrets. It's protected under the English common law. Okay, that's the first issue you need to address. The second issue is that not all inventions can be protected by trade secrets. If something can be kept as a trade secret within the 4 walls of a factory, it cannot be reverse engineered, then you'll be able to keep it as a trade secret. But if it's a mechanical product, an electronics product, once you put a product out in the market, somebody can purchase in the open market and analyze it and do a reverse engineering. You have no protection at all. Okay? You can't go back to say my secret is stolen. By very nature, to sue somebody for breach of trade secret, you must establish it was a trade secret and it was stolen from you, and then they commercialized it. That may be a difficult exercise. How do you prove something was kept confidential? It may be in files, it may be from a computer. So you must convince a court it was a trade secret. You have taken necessary steps to keep it a trade secret and it's not leaked out. So that's quite difficult. But if the product or the process can be reverse engineered, then you can't rely on trade secrets to get exclusive rights. And secondly, we're going to commercialize it. Investors will be very reluctant to depend on trade secrets to invest their money. They will ask for a patent. So if it is something that can be patented, a better choice would be to look at a patent application than to keep it a trade secret. But if it's a chemical product or some, say a recipe, for example, you may want to keep it as a trade secret, only if it cannot be reverse engineered. Okay.
Thank you. All right. There are some actually interesting stories or examples of trade secrets. I think one of the main ones that I like to refer to is WD-40, you know, the spray that's usually used in a lot of households. So I think maybe you'd want to look into that. I'm really sorry, I don't know who asked this question. Okay, but I hope that answers it. Okay, another question is, Malaysia's patent registrations are low. The number of registrations, I'm guessing, are low compared in this region. So from your point of view, why does this happen, and does regulatory issues contribute? Dr. Chris?
I didn't hear all that, but I think you're asking why patent filings are low in this region. Is that right?
Yeah. That's the question.
Yeah, okay, so I'm not sure it is low, actually. If you look at the number of patent filings in Malaysia compared to other countries, I sometimes ask Malaysians, actually, how where do you think you are in the world? If you look at the number of countries in the world, 180 countries, where do you think Malaysia fits? And most Malaysians say, well, somewhere in the middle. Actually, it's about 25. That's the number of where Malaysia is ranked. So after the developed countries like China is actually number one, then you get the US and Europe and Korea and Japan and the other big ones, and then some of the European countries. But then actually in this region, Hong Kong, Singapore and Malaysia are close behind. Malaysia files about 8,000, between 7,000 and 8,000 patent applications a year. There isn't, and actually it's relatively efficient, I would have said, compared to the other countries in the region. We're second really only to Singapore. I think Thailand is close, is not far away now. Thailand has had a big surge in applications. I think they got a lot of new examiners in the office, and that was encouraged by the Thai government to file more patent applications. But other than that, actually Malaysia is quite high up. Perhaps the question was, what about local applications? Because if you look at the proportion of where the applications are coming from, about 80% are coming in from abroad, and 20% are local. I think the local market in particular has taken a hit recently in the last few years because of government budget cuts. If you look at where most of the applications come from, it's the top, out of the top 10, maybe 7 or 8 of them are universities. And the government cut the university budgets a few years ago, and by the time, so the initial reaction was, well, we have to protect the research. So by the time you're thinking about intellectual property and how to protect that, actually there wasn't much money left in the budget to help out with that. So the universities in particular have been squeezed quite hard in terms of their filings. And again, I see that when I'm judging at the shows, there's people the researchers aren't filing as many applications, even though they're at the show, and that's something of a concern to me, because of course once you publicize an invention in Malaysia, you can't necessarily file a patent application. Having said that, we do have a 1-year grace period to self-disclosure, but I mean that we try not to rely on that because not every country provides that under the law. So in answer to the question, actually, I think Malaysia's better than most people think it is. If we can increase the budgets to the universities and encourage them to file more patent applications and just raise awareness generally, I think that would help protect innovation in this country and encourage innovation in this country. I think that's probably the way forward.
All right, thank you. Yeah, thank you so much, Dr. Chris. Okay, I just realized, Mr. Kandiah, you want to add anything to that?
Compared to what Chris said, I think from the apart from the research institutions, it comes to private companies and individuals, actually private companies, manufacturing companies. There's a general misconception that patents are expensive and it's not worth it. This misunderstanding of the system has got to be rectified. We need more seminars, workshops, and media coverage on patents, so that industries, they see patent as something that's useful. It's more an investment rather than a cost factor. Okay? So there will be a change in mindset in the senior management of local industries. Okay? Then they'll be filing for patents. Most industries think patents for the big boys. They are small players. Patent rights are not for them. So there's a misunderstanding of this concept of intellectual property rights. That is going to be rectified.
Okay. Okay, thank you. I just realized that it's almost 1:40 actually. So I'd like to wrap up the session. There are a few questions left, but I think we need to close it for now. And I'd like to just have some final comments, just as a conclusion, perhaps, on your final words from Mr. Kandiah and Dr. Chris. Mr. Kandiah, do you want to start?
Yes,
just to wrap up the session.
That'll be an interesting session. I think maybe MPC could organize more such webinars for industries itself. Why are they not filing patents? What are their fears? What are their concerns, and so on? And how can they interact more closely with my IPO? So their concerns also address my IPO. Okay, thank you.
Thank you, Mr. Kandiah. Dr. Chris?
Yeah, I think in summary, I mean, for me, I think Malaysia's actually got quite a good system already. And it's just a question now of kind of maintaining that position and improving it to become one of the, I think Malaysia could be one of the top ones. I mean, it already is one of the best ones, but it's just to maintain that position, you have to keep up with competition. So I think if we can continue to improve the systems, Malaysia will also see an improvements in intellectual property over the years.
Thank you. All right, it was a really great session. Thank you for being with us 40 minutes after the allocated time, perhaps. Thank you for staying with us. Just to wrap up the session, so on Patents Act in Malaysia, so far, there's a lot of improvement over the years that we've seen, as Mr. Kandiah actually shared with us previously, the processes when it comes to patent applications through the UK, and now we have our own, and we have about 80 examiners for patents in Malaysia, and perhaps there needs to be an allocation of more investments there, so that we can sort of maybe expedite and see how that can actually correspond better to the quality of patent applications that we get through the MyInfo. Timeline has been expedited that we've seen, and but there needs to be a consideration of direct technical expertise between the industry players here, the technical experts, with the government, either through the ministry, at the AGC chambers side, when it comes to final stages of drafting, to also involve the technical experts so that their points are not diluted at that stage, and it's reflected accordingly towards the final version of the legislation upon amendment. And also with the judiciaries, among the issues that remain for intellectual property, especially when it comes to patent disputes, is the rotation, the timeline in the judiciary and in the dedicated courts, as well as the background knowledge of the judiciary, that maybe they could use some additional support from technical experts in the judicial office. So thank you again for being with us. Please do take a copy of the handouts. If there are any questions that you still like to get the panelists to answer, please let us know. I'll try and get MPC to provide me with the names of some of the questions that remain unanswered, and maybe we can email that to you. I'll also share with Dr. Chris and Mr. Kandiah later. This is only if we can actually email the response back to you, because somehow I'm having issues seeing the names here. So I'll ask the organizers on that. And there would be some announcements, I'm guessing, from MPC. Okay. All right. MPC has a few announcements, and one of them here is the Virtual Advisory Clinic, the VAC. So this is a session where you can have a one-on-one appointment with RIA experts. So RIA is the Regulatory Impact Assessment. So to learn more about RIA, please join the Virtual Advisory Clinic, where we will explain the 7 elements of RIA. So RIA is one of the processes that has been, or an exercise that has been promoted at the OECD. So Malaysia has been adopting these best practices for the past 5-6 years, and most of the OECD members, including the World Bank, has extensively adopted RIA through its exercises or in various projects. And for any information on the VAC, please email MPC or access their website for the information. And also this Thursday, okay, you can see the email, the contact number through the handouts. on that poster, which I can't really see from my screen here. Okay, and please welcome, join MPC through the next GRP webinar series on the second part of understanding public consultation in Malaysia, this Thursday from 3 to 4 p.m. Okay, thank you again for being with us. I hope everyone enjoyed the session and got as much as possible out of it. Thank you again, Dr. Chris. Thank you, Mr. Kandiah, for being with us and sharing. Thank you so much. And please also, for the participants, please assist us by completing a survey form that is provided in the chat box. We would be happy to actually address some of the comments and feedback so that we can actually improve further our webinar sessions. Okay, thank you everyone. Have a good day and take care. Keep well.
Okay, thank you. Take care.
Thank you, Dr. Chris, Mr. Kandiah.
Okay,
bye.
Bye.